Hi, Max here with Frizzwoods, and in this video, I'm going to talk about some of the common defenses to possession-based criminal offenses here in Maryland. And when I'm talking about possession offenses, I'm talking about possession of drugs, possession of guns, and possession of stolen property, or as we call it, theft. First and foremost, most possession cases stem from a search or a seizure. So the most common legal defense is found in the Fourth Amendment, which is supposed to stop the government from doing any illegal searches or seizures, exceeding the scope of what they're allowed to do. So when we're talking about vehicles, we generally have a seizure of the vehicle and then a search of the vehicle. Both of those are areas of potential defenses when it comes to the law. So first and foremost, if an officer is stopping your car, even if it's pretextual, meaning he's really not stopping it for this reason, an officer must have a legal basis to stop your vehicle. So some of the common legal bases we see are equipment violations like tags, headlights, tail lights, third brake lights. Those are equipment issues. If there's an equipment issue with the car, officer might have a legal basis to stop it. The next is moving violations. So failure to stop at a stop sign, failure to use a turn signal, failure to obey a traffic control device, speeding. You get the idea. Either of those things are present, whether or not it's the real reason the officer is stopping you. A pretextual stop under Wren seems to be okay according to the United States Supreme Court. Once a vehicle is stopped, though, the cops don't automatically get to start looking around inside of it. They need to find one of the warrantless search exceptions that fit your case or get your consent. So it's important for your attorney to analyze the basis on which the officer searched your vehicle if you're charged with a possession offense that was something found in a vehicle. The most common, like I said, is consent. The typical trap is the officer asks you if do you have any guns or drugs in the car? Everybody says no. And then they say, well, then you wouldn't mind me searching, would you? And most people say, sure, when they should say, I do mind. Now, people are afraid that an officer might be able to use against them their rejection of a warrantless search. In fact, it's not allowed to be used against you, but most people don't know that. So, consent aside, what are some of the other common warrantless search exceptions for a motor vehicle? Well, what Maryland primarily used over the last couple of years was the odor of marijuana. Although currently, under Maryland law, an officer cannot search your car for the odor of marijuana alone. There are other warrantless search exceptions, including things like searches incident to arrest. But that's something you should probably delve in further with your attorney, specific to your case. So we've talked about reasons to stop a vehicle and reasons to search a vehicle. But I also said earlier that there's a lot of possession cases that are charged based on search warrants, searches of a residence or a business. If an officer applies for a search warrant, they need to write out an affidavit that they put in front of a judge. They swear it under penalty of perjury, and they swear some things out that have to give a judge belief that there's probable cause to search the thing. And they've got to be specific about what they're searching. So sometimes officers exceed the scope of a search warrant, other times officers put factual inaccuracies in the application. You can attack a warrant in the four corners of the search warrant. So have your attorney look at the search warrant. That's the basis for searching wherever the thing is that was found, and maybe that might be a defense in your possession case. So those are some of the common legal defenses, but we also have factual defenses to possession cases. For this illustration, I'm going to use this handy Frizzwoods pen here. Right now, I am in actual possession of the Frizzwoods pen. It's on my person, right? But now I'm going to put it down on the table in front of me, and I'm going to invite into the room some of my imaginary friends who you're going to imagine are here with me. Now there's four of us, and there's one pen. It's within the grabbable area of all of us. The state may try to put on a case of what we call constructive possession. A constructive possession case is just that, one where you could construe that the person might have possession, but they don't have actual possession. And unfortunately, four or five people can be charged with possessing this single Frizzwoods pen under the law. Now, your defense might be that you didn't possess it or didn't know it was there. That's a factual defense to a possession offense. The last and final common defense that I'll talk about is specific to the type of thing that you were alleged to have possessed. So, for example, if this Frizzwoods pen was, let's say, a bag of supposed cocaine, a common factual defense might be that it's not actually cocaine. And your attorney may ask the state to prove that it is. And they have the obligation to do so, but if you ask for a trial, the state might have to put on the chemist that tested this bag of cocaine to convince a judge or a jury that there is, to a scientific certainty beyond a reasonable doubt, proof that this is actually cocaine and not baking soda. Same might be true in a firearms case. Some of Maryland's firearms offenses, like the wear, carry, transport statute, but have legal requirements that the state prove operability of the firearm. Other statutes like possession, illegal possession, or possession under 21 have a definition of a firearm that could be something as simple as a frame or a receiver. So we're not talking about a functional firearm. But some of the firearm offenses in Maryland require proof that the thing is actually a functional firearm. The other crime that I mentioned was theft, which also has an intent element, although typically in the possession of stolen property and possession of recently stolen goods, the state might have to prove that you knew or should have known the things were stolen, and you might have a defense that you did not know or should have known because you purchased it from somebody, for example. So, I've talked about some of the common defenses of possession, but every single case is different. And it's important that if you're charged with a crime, you speak with an attorney, hire an attorney who can individually analyze the facts of your case. If you have a Maryland criminal case and you'd like to speak with us, we have a 24-hour attorney line and we'd be happy to talk with you about your case. Good luck.